And welcome back, John Morris Show on a Thursday. We're going to welcome in now our legal expert, Dan Hare. How perfect is this? I texted Dan. Good morning, Dan. How are you?
Good morning, John. Good to see you.
You too. Thanks very much for your time. Not in Waco. And isn't it ironic? Tell everybody you're in Houston and tell everybody what you're doing there.
Yeah, well, this week is the State Bar of Texas annual meeting, and the entertainment and sports law section that I've been a part of for a number of years and on the board of that. We have an afternoon session of continuing education programs, one of which I'll be presenting this afternoon on sports litigation over the last year. And so no shortage of topics in that arena, including what we're going to be talking about today with Brendan Sorsby and anything else you want to talk about. So yeah, it's all timely for sure.
Very good. Very timely. I said earlier, we could have you on a weekly segment, and there's so much going on in sports litigation these days. But we appreciate your time on the road. Thanks very much for that.
Of course.
The Brendan Sorsby story saga continues. It's really, top the headlines. First off, just give me your general thoughts on first his eligibility, his question about his eligibility, and then the temporary injunction that at the moment will allow him to play this season.
Sure. Yeah. And this is one that really has struck a chord, it seems like, across the country. So I think there's been so many eligibility lawsuits filed really in the last couple of years. And I'll be talking about some later today but this one in particular, earlier in the year, we had Trinidad Chambliss was a big one, and at Ole Miss that kind of caught waves. And then this one too. This one's different, obviously, with him having been alleged of gambling on his own team and various other sporting events, which all of that is in violation of NCAA rules. And so, NCAA quickly, deemed him ineligible due to that. And he got a good team of lawyers that was able to, in Lubbock County, get an injunction, a temporary injunction to prohibit the NCAA from enforcing its rule against him. And the main, the thing that's a little bit interesting here is that, the court issued the injunction. It's really only about a 2.5-page opinion. It's not a substantive legal opinion that gives us a whole lot to go on as to why the court felt that this was the right thing to do. It kind of just walked through the basic elements of what you need to issue an injunction. But basically, it's essentially saying, and what the plaintiffs really argued was that the NCAA is arbitrary in the way that they apply these eligibility sanctions on student athletes, and that they didn't provide some mitigation relief to Brendan Sorsby on account of his addiction to gambling, the fact he was seeking help, and they just kind of issued a straight across the board, no mitigation, just a suspension for the rest of his season coming up, and therefore his career. And his team was able to successfully argue that was not appropriate. And so right now, as it stands, with a 2-game suspension at the first of the year, then he's eligible to play for the rest of the season. Of course, then the fallout from that has been, especially amongst the Big 12 athletic directors, presidents, and others, coaches for other teams in the Big 12, that this is ridiculous, that betting on your own team is just a hard and fast kind of rule that should never be broken and doesn't really matter. And that, how do we handle this now as a Big 12 conference in whether to sanction him, the Texas Tech, or to allow for schools to not to play Texas Tech this year, which is what some are talking about, kind of extreme measures along those lines. And it's still a lot of unknowns as to where it's going to ultimately end up.
Yeah, a lot of unknowns for sure. Next step would be the expected appeal, and the NCAA has done that. And how quickly can that happen? I think they termed it an expedited appeal. Something I saw said it wouldn't even be heard until February, which means the season would be over. But what's the schedule on the appeal?
Yeah, so and that is one of the factors that we've seen in so many of these cases, right, is once the injunction gets issued, the appeal process for those injunctions do tend to take months and months. And so the player is usually able to run out the clock on that, play their season, and then they no longer have a need to be in litigation anymore. So they just withdraw their suit and they're done. And that's bothered the NCAA because they want to get some appeal rulings in their favor on some of these cases, if for no other reason than just to get some established precedent to overturn some of these injunctions, even if the player's already played and there's nothing to impact the player. With Sorsby, we'll see something a little bit similar. I think, that the schedule for the actual appeal would not be heard and be decided certainly until after the season. And the only possibility that I've seen a couple of folks talk about, and I think is probably unlikely, is that you can ask the court to stay the ruling from the trial court, meaning to basically kind of put it on pause while the appeal is being heard. And that's, I'm sure, something that the NCAA will seek in addition to the appeal on the merits of the injunction. But yeah, I think at this point, I think we have to kind of assume that Sorsby is going to be eligible to play under the court order after the first 2 games. And so then it becomes kind of a question of, Tech does have a decision as to whether or not to play him. I think we all can kind of read their posture that he's playing. I don't think they're backing down at all. So, and then it's really then back to the Big 12 to determine if they're going to try to take any action. And that's certainly going to be met with legal challenges from Tech. They've said as much in the last 24 hours. If the Big 12 tries to sanction either Sorsby or Tech under some of the Big 12 bylaws that allows them to do that, the presidents can get together and decide we're going to sanction, fine, not allow participation in the championship game, something like that. They could do those types of things, but that's going to lead to essentially another legal battle on that question.
Yeah. I'd be interested in your opinion on the NCAA. They just get sued every time they turn a corner. And am I right? For the most part, that has it's kind of neutered the NCAA on a lot of decisions that they would like to make or probably would make, but maybe don't because they feel like they're going to get sued, and why go through the trouble?
Yeah, I mean, I think they're definitely getting sued all the time. They're fighting most of these cases, and they have had for a lot of the headlines of how much they lose. They actually have had some wins in some different places. The Bediako case out of Alabama earlier this year, they eventually won. I'm kind of drawing the line on if you go to play professionally and then try to come back to college, there's not an exception for that. And so at least in that case, they were able to win that one. Joey Aguilar's case out of Tennessee was another one earlier in the year that sort of tracked along Diego Pavia's line of extra year of eligibility based on junior college participation. But they were able to prevail there. And so they've been able to kind of draw a couple of places in the lines in the sand where they've been successful. But yeah, for the most part, they're fighting on multiple fronts across the country and in federal and in state court on antitrust grounds and on grounds of state court claims like arbitrary application of rules like Chambliss, like Sorsby. And so, it's made it a real challenge for them. And when you have, one state court decision in Texas or in Mississippi, really that only applies to that player and in that jurisdiction. So it in theory doesn't really have application across the country, but it really does, because then, of course, it just leads to more of those same types of lawsuits being filed in other jurisdictions. And then it's, it creates this kind of patchwork of, what do we have a national, through the NCAA, a national regulatory body on college athletics right now, or is it really a state by state and court by court type of jurisdiction? And I think that's where the NCAA and others have been trying to get Congress to intervene unsuccessfully over the last 5 years, and to try to kind of establish more of a nationally enforceable system. But that still seems far away, even with the most recent Senate bill from Senators Cruz and Cantwell, which maybe has the highest chance of anything, but still a long shot probably. And so in the meantime, it's just a kind of a case by case and jurisdiction by jurisdiction situation that we're in.
Wow. I've heard and read over the last few days that this may be the low point, in these type situations in college athletics. If it is the low point, and we don't know at this point if it is or not, but I've also read and heard that this could be the tipping point, that this might lead to substantive change. Do you think that could possibly happen?
So, yeah, I think on that kind of existential front of college athletics, the thing that seems, the two pieces really that seem the most likely, maybe not in the next year or two, but the next 4 to 6 or something along those lines. The really two main things that I think are out there are, could particularly the Big Ten and SEC with maybe a few others create, kind of a super league or some type of joint venture between them, and then just start creating and enforcing their own rules apart from the NCAA, or at least with this as it pertains maybe to football and basketball apart from the NCAA. I don't know, I know I think that conversation has gotten more prevalent over the last, couple of years, and for sure in the last 6 to 12 months, but still maybe something far away. I think the other thing that is always on the table is collective bargaining with the particularly football players, but potentially basketball as well. And the main reason for that is because collective bargaining is kind of the one thing you can do that makes the rules that are in place in the collective bargaining agreement safe from antitrust challenge. And so so many of these cases, not Sorsby and Chambliss wouldn't fall into this group, so this doesn't really impact that, but so many of these cases are antitrust challenges, and if the conferences or the NCAA somehow come together to form a bargaining unit with or bargaining CBA with a group of football players, basketball players, then as long as everything's being done within the context of that CBA, then the rules would be enforceable and the players wouldn't have the ability to sue under antitrust law. And so, the presidents and the NCAA have all been resistant to that, for this whole period of time. Meanwhile, they keep getting sued under antitrust law and losing a lot. And so, at some point, you kind of have to figure out, okay, can we create a legitimate collective bargaining situation? And it's not easy to do. You probably have to use the conferences as the employers, just because so many of the universities are state, and government entities. That kind of complicates things on a school level, but the conferences could potentially be the employers. But it's not easy, and it's going to take some time. And so those are kind of the existential things that probably at some point are going to happen, or in some combination. But we're not there yet.
Yeah. Gotcha. Good. That's good information. All right. Final thought. As of today, Brendan Sorsby can play football. He can suit up for Texas Tech after he sits out the first 2 games. Between now and then, who knows what's going to happen? But do you think that third game of the season, I think it's Tech versus Houston, their conference opener, do you think Brendan Sorsby will suit up and be on the field for the Red Raiders?
I do. Yeah. And I'm not 100% certainly sure of that, but yeah, I definitely would assume that the likelihood is much higher than 50-50 that he's playing in that third game. And that's going to be interesting. Obviously, I just even think through the, outside the legal piece, just the practical implications of, how the opposing crowds as he goes on the road, particularly I think they go to Cincinnati, where he transferred from. That was already kind of a game that probably was circled on calendars in Cincinnati, and even more so now, and what that's going to look like. So yeah, but I do think he's going to play. I would be surprised if he didn't, I guess, at this point, but we'll see. Like I said, maybe they're able to stay on the opinion and legally kind of rein it back. But I don't think so. And I don't think the Big 12 and those presidents are going to wind up actually doing anything in terms of him playing. Now, they may still do something to Tech or try to sanction Tech. But that wouldn't stop, I don't think, them from playing Sorsby and then just trying to fight the NCAA or the conference on school-based sanctions.
Yeah.
So
Interesting. Yeah. Really interesting. Well, thanks for your time. I knew you'd have great information on this, and you do. And we appreciate your time, and maybe have you back because I think some of these things are going to keep popping up. But be safe. Enjoy Houston when you're down there.
Sounds good, John. Thanks for having me on. I appreciate it.
Thanks, Dan. Appreciate it. Daniel Hare, he is our legal expert here on the John Morris Show, and you can see why. Explains those situations very well. Formerly with Baylor Athletics and the Baylor Law School, now works with Rainey and Rainey here in Waco.